Tazaki ya Hakala ya Kabbalah. Anya Abamar, Anya Abamar. You Almighty Allahayim. I say, nah, stand still. Hana Tazaki ya Hakala ya Kabbalah. Anya Abamar, Anya Abamar. You Almighty Allahayim. I say, nah, stand still. Hana Tazaki ya Hakala ya Kabbalah. Anya Abamar, Anya Abamar. You Almighty Allahayim.
I got some things in my chest, I don't know how to express. While I'm walking down the cold road to pass every test. Now look, I can't eat, I can't sleep. Y'all save me from the water, cause I'm going in deep black. People keep talking, always deceiving. Try to break it down, but you gotta keep believing. Whoop down the Bible and let it say to Peter Pan. Praying for the people, cause we all gotta stand. Wonder was a lollipop to the grandma in the on guy. It's a cold world, trying to break the truth out. People get paid to check, pill sell out. Lying on the word, but it ain't no other way out. To my work, gotta never give up. People across the world, everywhere, keep eyes up, eyes front, look. Press to the mark, yeah, man, and high collar. Go, come and see a man that'll love it when you're falling. Forget him, bomb the enemy, I'ma run to the way and the truth and the light. I spot, bomb packs, I'ma say it every day and night, man, I promise I'll fight. Light 'em up, I don't need no match, how you buy all by yourself, let me get my breath. I guess this with the hook gon' be, man, so drop that, man, I repeat myself. I don't need no match, how you buy all by yourself, let me get my breath. I guess this with the hook gon' be, man, so drop that, man, I repeat myself. I will not be ignored, I've been quiet too long, struggle ain't easy, that's why I'm always on my own. Been weeping all night, but joy come in the morning time. So down on my knee, I get it, yeah, no praying for a sign. Remember Tulsa Massacre, that ain't been long ago. Although we ask for reparations, bro, we get that where we go. It's hard to believe the sight, even though it was real. And I pray we all call on y'all, cause in hell it ain't no milk and cooking. Every check bounce, if it can't avoid it, or you but never got paid, every turn of y'all. Willing to say we sin, could be sick about the spoilers, so we call it to the Father. What a hurt for 12, bro, in the sun. Why boom one another with a one-track mind? As if everything we see is even wider nation from the north. Break the land and come out with the agents of our own flesh, spraying one another with a murderous brutality. Ask about the lost sea, hear the sheep scatter like a person is a cocaine. Every day in the battle, building muscle, sealing muscle. Get a crowd of people in the trouble. Here ain't my strength. Bomb the enemy, I'ma run to the way and the truth and the light. I spot, bomb packs, I'ma say it every day and night, man. I promise I fight. Light 'em up, I don't need no match. How you fire all by yourself, let me get my breath. I guess this with the hook gon' be, man, so drop that, man, I repeat myself. I don't need no match. How you fire all by yourself, let me get my breath. I guess this with the hook gon' be, man, so drop that, man, I repeat myself.
Shalom, Mashbaka. So I'm finna go ahead and cover this. There's been an update to Brother Marcellus Williams on what's going on with him with the courts. I'm gonna go ahead, y'all are willing, and get started with sharing what is going on with our brother now today. And I want y'all to pay attention. This is the Supreme Court. I'm not going to listen to the whole thing, but this right here is the Supreme Court on what they're arguing about right now. And so y'all can go ahead and listen to the full thing once the broadcast is over, or you could go and listen to it now and come back, but I'll be gone by that time. So it's really up to you what you want to do, but the audio for that was already recorded. Shalom, Sister Melanated Queen. It's good to be here. Good to see you here, sister. Hope you've been doing all right. I'm finna go ahead and drop this so y'all can hear it. So just listen, fam.
That's why it would be appropriate to remand this back to the trial court and ask for Judge Hilton, who is in that courtroom, to issue these findings of fact with respect to all these issues. And what I would also note, Your Honor, is on top of Judge Sippel's ruling, what we saw then over the weekend is that Judge Kelly in the Eighth Circuit said that she was extremely troubled by the exact same conversation that occurred. So I don't think that, Judge Sippel's argument is really going to be with the deciding factor here. The important part, Your Honor, is that with respect to the Batson violation, what happened is once the trial prosecutor was placed under oath and subjected to cross-examination, he said the quiet part out loud. He admitted that there was actually a racial component here, and that is unconstitutional. When this court issued its original ruling, the court's wording was very, very careful. It said, when the trial prosecutor had said that they just looked similar, there was nothing, quote, overtly or, quote, inherently racial about that. Now, it has become overt. It was expressly stated that there was a racial component. And that is what is so important here. And I think that there's a reason that you don't see that in the Attorney General's brief, is they really don't want to address the actual statements that were made. He said he struck a juror in part because he was a young black man with glasses. That is unacceptable. We cannot stand for that. Just because we're hearing about it 1 month before an execution date doesn't mean that it's too late. That is the entire purpose of 547.031, is it allows us up to the last moment to come back and correct an injustice. This was a bipartisan bill that was passed by the General Assembly and signed by Governor Parson. This is not activism. This grants the right to every single local prosecutor in the state of Missouri, when they see an injustice, to come forward and correct it. That's what happened here. This is a trial prosecutor where this is not his first Batson violation. Judge Ross, when he was still a state court judge and before he became a federal court judge, also found that this trial prosecutor had committed a Batson violation in the McFadden case. This is not the first time. Also, we have the trial prosecutor's notes from this trial, except for one component of it, the voir dire notes. That is incredibly suspicious. And that is one of the reasons that it led the prosecuting attorney's office to bring this. Because this is someone who had a history, and what we've now heard is that everyone's worst suspicions were true. There was a racial component of this. Another important part about this is, in the years since this court issued its original decision in 2003, there's been a lot of development on the Batson issue within the U.S. Supreme Court. What we're now seeing is, this is an example where the trial prosecutor had already struck 5 of the 6 black jurors with peremptory strikes. That's the same issue that this court later saw in McFadden. It's the same issue that the U.S. Supreme Court is later seeing in cases like Flowers, where the sheer number of peremptory strikes being exercised itself is an incredibly important indicia of whether there was a racially motivated, but you don't even have to get there because he testified to it under oath.
Mr.
Okay, so now the judge is going to speak on what she's going to say. I'm not going to say it before they do, because I want y'all to hear the judge ask a question, and then the prosecuting attorney is going to speak after this. Now, the other guy is a prosecuting attorney, but he's taking on this case because there's injustice going on with this case. So a prosecutor is standing up for the Constitution and saying that this is unjust, it's not law. And so what they're doing is they're trying to counterattack this person with the defense attorney thing, what they got going on. Now, I'll show y'all a law. Y'all willing? I'll show y'all a law that it's against the law for a prosecutor to prosecute somebody that's innocent. So let me go ahead and let them finish on playing, and then I'll be right with you.
Potts, if I could interrupt you just for a
Yes.
minute, please. Is it my understanding that, that you and Mr. Bell conceded the actual innocence claim at the trial court? That you did not proceed on the claim of actual innocence that was filed originally?
Your Honor, that's correct. The prosecuting attorney's office, based on the development with the DNA evidence, did not press the actual innocence claim further. And what ended up happening was, at the last minute, because everyone was frankly pretty shocked about the DNA findings, is that it was amended to add the Youngblood claim. I don't think that the actual innocence claim was formally deleted from the motion, but it was not pressed as grounds for relief. So
And you didn't make any findings in your proposed judgment as well regarding actual innocence?
Correct, because what had happened based on the Youngblood claim is, as I said, everyone frankly couldn't believe it, because you had this same trial prosecutor who's admitted that he's struck at least one juror, in part because he's black, who said that he handled the murder weapon not once, not twice, but 5 times before trial without gloves.
Were
Now we see that that's tampering with evidence right there. I'm gonna let it play.
those incidents, though, after the item had come back from the lab?
Yes, Your Honor, I think it was within a matter of 10 days of the murder being committed, which was multiple years before the trial, is when he said he thought he was allowed to start handling the evidence at his will, based on what his theory of the case was. And we think that, and that's why we believe that that is bad faith. Trial prosecutors don't get to decide what happened. You have to follow the evidence. You don't get to decide what occurred and make decisions that you're going to handle a murder weapon. I mean, this is the knife.
Certainly not today, but what was known about DNA evidence was different in 2001, wasn't it?
And, and I'll gently press back on that. DNA was well known. To give you a context, CSI was already out in terms of the television show. Everyone knew about forensics. There had already been a reversal in the St. Louis County Prosecuting Attorney's Office in 1996 based on DNA evidence. And I see my time is up for the moment.
You can finish answering the questions.
Yeah.
Go ahead.
And so, Judge Ronnie, so to continue, DNA was incredibly well known, and this was actually the exact same year when the Missouri General Assembly passed the Post-Conviction DNA Act. It took effect, I don't know, maybe 2 months after this trial actually occurred. We weren't in the dark ages on DNA. This is something where everybody knew about DNA, and the General Assembly was passing legislation about it. Thank you.
Thank you, counsel.
Okay, I'm finna prove this. I'm gonna prove what he said was true. And then I come back to the case and y'all can hear what the prosecutor is gonna say. All right, so let me go ahead and drop this and pull up that right there. All right. This right here, if your screen is blurry, go to your right hand side on your device, click on quality, go to advanced, and click on the one that says 720p, and it should clear up enough where you can see it very clear. Right here it says the first time DNA evidence was used in a criminal case was in 1986. 1986. Now, I was born in 84, like brother Moshe. So if in 1986, that's when they started using DNA, how can the prosecuting attorney go against this? And I'm gonna let you listen to him. You hear the judge saying the same thing, that back in that days there wasn't no DNA really. So right here it said the first time DNA evidence was used in a criminal case was in 1986 to solve the murders of 2 girls in England. details. You can check that. And they show you the Wikipedia, and Wikipedia send you to the source. Like I say, National Institute of Justice, archives, what every first responding officer should know about DNA evidence. That's why when people was getting a 21andMe thing done, it was showing that our people DNA matched the bones that was in the Lachish relief. Our people matched the DNA of the people that was in the middle of the East before they came over there. All right, case. The rape and murder of Linda Mann, M-A-N-N, in 1983, and Don Osworth in 1986. Now, this is way before I believe 1998, when my granddaddy, my great-grandfather died, who was born into slavery on the plantation. My granddaddy was born like around the 1920s or something like that. Great-grandfather, his name was Willie Ivory, and he got his name by his daddy and them renaming themselves because they took us from the Ivory Coast, Cote d'Ivoire, and that's found in Uganda. That's the place where they say is Waida, the Kingdom of Judah was at. But anyway, the rape and murder of Linda Mann in 1983 and Don Osworth in 1986. Richard Buckland was arrested and charged with the murders, but confessed and then retracted his confession multiple times. All right. DNA fingerprints was used to link the two crime scenes and identify Colin Pitchfork as the culprit. Pitchfork was arrested in 1987 and sentenced to life imprisonment, not the death penalty, life imprisonment in 1988. So they saying that with Brother Marcellus, which is a whole total different case, with Brother Marcellus, his fingerprints was not found on the knife. None of his blood, DNA, or anything was found on the knife. And you got to remember, like I'm showing y'all, that in 1986 is when they first used this. This brother been locked up for nearly 24 years. So 24 years from this year is 1998. And like I said, that's the year that my grandfather had passed. All right. I remember that year because Tupac, and I made an error on the last one, Tupac died in 1996. Biggie Smalls died in 97. And my grandfather died in 98. And in 98, this right here was used. How many people they was picking up? They were saying because of DNA. Have y'all ever watched the late night TV shows that used to come on TV? What they say? Law and Order, with the bell go boom boom and all that. Yeah. So they was doing DNA evidence and tests back then. And we're going to read over this right here again. And as you see, as the lawyer said, and if that's not true, but the lawyer said, because this is the time they got left, and the lawyer said they only got 1 day left. Look at this. He got 1 day left. And they asking him to do work that would supersede that 1 day in order to prove this man's innocence, even though there is no fingerprints or anything that puts him on the scene of the crime. So they convicted him first-degree murder, robbery, and burglary, and they sentenced him to death. Look, incident date 08/11/1998. Like I said, conviction date 06/15/2001. I think that's around where the trade towers was going on. S is accused pleaded guilty. Accusee of pleaded guilty. No, he did not. Contributing causes of conviction. Informants. So the informants was the contributing cause of conviction because the murder weapon was touched and tainted with, and even before it was tainted with, there was no fingerprints or DNA or anything found on him. And how can somebody go back and check anyway if the people that took him in wasn't checking it? But how can they go back and check it anyway if they checked it and they went and put their handprints and stuff all on it, tainting the evidence? So the only way for them to try to convict him was through informants. They got 2 informants, as we're going to read today, and his penalty for them, for the informants' testimony, not forensic evidence or anything, as the judge pointed out, that they didn't use forensic evidence and stuff back then, but they did. It was accessible. So it's a death penalty case. Yes. So and race of victim was a Caucasian female. Status active. So the status of him being put to death is still active. So what the court is going to ask this brother lawyer to do is going to be unethical. And I'm going to read the information again. Don't worry. But what the judge is asking for this brother's, and reason why I say brother is because he's my brother according to blood. We're the same bloodline, and they're going to try to make an argument against that as well. But we are blood kindred because every nation comes from a founding father of that nation. Let me go ahead and share the Supreme Court again so y'all can hear further on what they saying, and then you can hear what the prosecutor is going to say. And I'm going to try not to interrupt as much. So here we go.
May it please the court,
May you
I'm
proceed?
Michael Spillane. Let me correct some things. The prosecutor was not cross-examined. He was their witness. He was examined on this point on direct. What did he say when asked directly, did you strike someone partially, was part of your reason for striking someone because he was black? He said, no, absolutely not. Absolutely not. And he explained that that would be a violation of Batson. What they did, and I think you can read the transcript and follow it, is just kept asking him little snippets of questions from the trial court record, not letting him make a full answer, and then waiting for a spot where they could say, gotcha. But he did not admit that he struck a black juror partially because he was black. He said, no, absolutely not, absolutely not. And the district court where we did this last week looked at that transcript and said not only are they mischaracterizing the record, you can't even draw an inference from that record.
And didn't the trial court in this case, didn't the trial court make a finding that the prosecutor denied striking the juror because of their race?
Well, he didn't, but it's in the transcript. I mean, he made 3 findings. One of them, he said the prosecutor denied striking, broader striking people because they were African American. He said that this court had already dealt with the same issue. And a third finding, which I don't recall, but it was not specific to this juror, you're right. But then the case law, which is in our brief, teaches that if a finding doesn't address something, you make the finding in accordance with the decision. So that said, there's no clear and convincing evidence here. There's no evidence at all. And it is the same thing on the Youngblood spoliation. The prosecutor testified and the judge found him credible that he never heard of touch DNA until 2015. This was 2001. He said the practice in the prosecutor's office was, after all the testing is done, you handle weapons without gloves because there's no reason not to. And their expert didn't disagree with that. Their expert was talking about testing in labs at that time, where they go to the lab and they test it, and of course they wear gloves. When she was asked on cross-examination, do you know anything at all about the procedures in the St. Louis County Prosecutor's Office at this time? Her answer was no. So she helped us on that.
Is touch DNA different than regular DNA
Yes.
testing?
Yes, I didn't mean to talk over you, but
No,
regular DNA, which the prosecutor's office used at that time, was fluid. Touch DNA is if you like hold a gun or a knife and some of your skin cells, perhaps a very small amount, are on it, then you can magnify those, and there's a procedure to make enough of it to test. But the prosecutor never heard of that in 2001. His testimony was he heard of it in 2015. I mean, kind of off the record, I believe it existed in Europe in the late 90s, maybe 1997, but there's no evidence in the record that anybody in St. Louis had ever heard of it. So there was no reason to touch the, to wear gloves on the knife, because as the prosecutor said, there would have been no point in it. And we know he wasn't trying to destroy evidence because we know there were fingernail clippings. And he was very careful that those could still possibly be tested in his beliefs. So he said, I'm not going to open this package without wearing gloves because I don't want to contaminate it. So he wasn't trying to contaminate anything. As far as the fingerprints that they talk about, their brief refers to bloody fingerprints. There were no bloody fingerprints. There were fingerprints, and there was testimony at trial from the fingerprint examiner that we destroyed fingerprint lifts that were unusable because we couldn't compare it to anything. They're unusable, that's what we do. That isn't bad faith destruction of evidence. Something else they said, that the reason they brought the case was because of the prosecutor's notes that were missing, or part of the reason, if I understood them correctly. If you read the testimony of their investigator, it's the last one in the transcript, he said, we went down and got the file out of the locked vault where it had been locked up for years in February 2014. They brought this case, February 2024. They brought this case in January 2024. They brought this case by looking at this court's decisions and saying, we can attack that one. But they did not go and actually look at their own file for another month. So to say that that's the reason they brought this case doesn't fit with the testimony, and I'd invite you to look at the testimony of their expert. Before I move on to other things, are there any questions on that bit? All right, I would just say this, the standard is clear and convincing evidence, which is evidence that instantly tilts the balance in the favor of the proposition they're offering against all the other evidence. On those two claims that they've mentioned, there's no clear and convincing evidence. There's no evidence at all. And I think the judge is kind of a hero here because he stood up and followed the law. And I would say that about the prosecutor. There are all kinds of things saying bad things about the prosecutor, that he deliberately in bad faith destroyed evidence, that he struck people because they were African American, and that's in the briefs, and it names him by name. But that's just wrong. He didn't do that, and he shouldn't have his reputation trashed for this without any evidence at all. I will talk a little bit about jurisdiction. I'm not sure there is any. I think you've read our jurisdictional statement. 511020 talks about if something disposes of all the issues in the case, it's a judgment. Here we've got it denominated as a judgment. It's dated, it's signed, and it disposes of all the issues. So I think this is a judgment that isn't final yet. So that's something the court will have to deal with. Maybe it could address the merits in the context of the stay, but I'm not even sure the case is before you. As far as preservation, your court has read the briefs on preservation. Their brief has managed to unpreserve the issues that they had preserved. Everything they have is unpreserved. The first point relied on Batson doesn't say anything about a Batson error. It talks about the form of the judgment not addressing X, and then it goes into, in the body of the text, part of the argument is, well, the merits of the Batson violation. But that's not in the point relied on. So the argument is multifarious. The part that's in the point relied on was never raised below. They could have filed a motion, as they're required to under Rule 78, to say we didn't like the judgment. They didn't do that. So the part in the point relied on isn't preserved, and the Batson itself isn't in the point relied on. So, I mean, they've managed to unpreserve that. As there's a similar thing with the Youngblood, because the Youngblood is multifarious in that it raises both the fingerprints and the knife handle. So that's not preserved. And then the third claim is the point relied on only talks about the time, the 4 hours that they had and the 2 hours that I had, but it doesn't say anything about the time as far as months or how long it took that they had to prepare for trial. So that's not in the point relied on, but more importantly, it was never raised at the court below. If they wanted to have more than 4 hours, you could read the transcript where I got up before opening statements and made objections to things I didn't disagree with. They didn't do it. They didn't say anything. Apparently, they agreed to the 4 hours. And then they lost, and now it's like, oh, the trial court committed error by limiting us to 4 hours. Well, it's wrong to not tell the trial court that and then say, oh, the trial court is bad. It shouldn't have done that. The trial court did not violate their rights at all, and certainly not their due process rights. Did the court have any questions about that?
Counsel, on the third point about the length of the trial, doesn't the record reflect that neither side used the full time allotted?
That's exactly right. I believe, and I didn't take notes, one of the attorneys that was with me did. I believe I had, I don't remember exactly what I had, but I remember the prosecutor had, I think, 13 minutes, and Mr. Williams had, I think 27 or 37. It may have been 37. So that would have been a total of 50 when they went to closing arguments. And nobody jumped up and down and said, I need more, I need more. This is just working back and trying to find error. And there isn't any error there. And as far as saying they didn't have enough time, they brought this case in January 2024. The district court on 6/5 in June 2024 set a scheduling conference. They didn't do a doggone thing. The plaintiff has the duty to pursue a case. That's why there's a whole body of law about dismissal for failure to prosecute. But they didn't do a doggone thing. They waited until the judge set the hearing, and then now it's like, oh, we didn't have enough time. Well, maybe you should have done something in the first 6 months that the case was sitting there and you were doing absolutely nothing. There's also a statement in there that I promised to do an answer or something. If you read the notice of intent to oppose that I filed in February, it just said the Attorney General's office intends to oppose this proceeding. It doesn't say I'm going to file an answer. There wasn't anything that I could really do until they prosecuted the case. I guess I could have filed an answer, but I don't have to prosecute it for them, and it's not my fault if they wait until the last minute, which they did, to put this case in front of this court the day before the execution.
Okay, I think that's enough. What he's saying, literally, all he's saying is that they had all this time to present this information, and they never presented the information. So henceforth, it ain't his problem. He ain't the one did it. But no matter if he is the one did it or not, what we talking about is an innocent man. And I go back and let the defense attorney clear his name. But let me go and show y'all. This is all the people that's on Missouri death row right here. So it's people still being put to death in America. Some states passed it and some states didn't. Now, like I told you, I remember I said brothers and sisters. So okay, people on Missouri death row. Okay, these are 10 people currently living under death sentences. Excuse me, under death sentences in Missouri, and 8 are eligible for execution. Below, you can read information about them. Information is listed: last name, first name, county sentence, race, year sentence, victim information. Okay, Anderson, Terrence, Butler, Black, 2001. White male, white female. So say victim information. Year sentence, victim information. They put white male like that, like the lawyer said. White male, white female was the victim. They didn't just put the name, they put white male, white female. Okay? Boylick, Williams, Camden, white. Like I told y'all, there's some white people in there. 1984, that was the year I was born, and Brother Moshe. White female. So something happened with them. Boylick, William, Camden, white. See, they classifying them with racial status. Collins, Christopher, Pelps, white. 2012, white female child. What happened with that person? 2012. Emory, Richard, St. Charles County, white. 2022. 2 white females, 2 white children. Mathenia, Charles, Jefferson, white. 1985. 2 white females. M. Faden, Vincent, St. Louis County, black. You see that? 2008. Black male, black female. Polar Roosevelt, Cole, black. 1986. White male. What happened to the white male? Shockley Lance. You see how they just put it? White male. Black and black male, black female. They ain't put their name. They just putting racism is classifying somebody by black or white. That's racism. So when they say black male and black female, when they say white females, 2 white children, let's go here. Shockley Lance, Carter, white, 2009. Remember the year, I think that's when Michael Jackson passed away. White male. William Marcellus, St. Louis County, black. Y'all see that? 2001. White female. He was sentenced to the death penalty in this case. So whatever reason, the lawyer brought this case back up because of the insufficiency in evidence, because you know that they have a program out now where they're trying to look over somebody's case again, and they just sentencing these people to death. Wood, Craig, Green, white. Say he white. White female, child. Not eligible for execution. Sentenced by judge when a jury deadlocked. Sentenced as a teenager. Missouri death row. Exonerators. There have been 4 persons exoneration from Missouri death row since 1989 so far. These are the cases in which a person was wrongfully convicted of a crime and later cleared of all charges. So if they're not going to look into the evidence, why don't they just allow him to continue his life sentence in prison if they're not going to allow him to look into that? So because they opened up the case in 2001 because of a program that was set up to let innocent people go, Why would they want to do that? So, okay, if we not going to look into the evidence, if anything go wrong, we just going to put these people to death. Y'all see how they doing? Based on new evidence of innocence. And it said, read more about Missouri. Missouri execution since 1976. There have been 97 executions committed by the state of Missouri since 1976, when the death penalty was reinstated in the United States. What was going on in 1976? And they making this decision. Come on, Mashpaka. Look at here. That's a brother, ain't it? Wrongful executions. Larry Griffin. The state of Missouri executed Larry Griffin on June the 21st, 1995. Griffin's execution has been considered one of the top 5 most wrongful executions. He was convicted and sentenced to death for the 1981 shooting murder of Quentin Moss. Griffin maintained his innocence until the end. There was no DNA evidence, just like with the brother Marcellus Williams that they trying to execute tomorrow. There was no DNA evidence linking Griffin to the murder. And the 1981 conviction relied on the testimony. So, Brother Moshe, this before me and you were born, on the testimony of a single key eyewitness. Now, I don't know when some of y'all was born, but if y'all want to put y'all year when y'all was born, you could just put 19 so-and-so, 19 whatever. And if you a sister and don't want to put the year, just say happy birthday. But it say rely on the testimony of a single key eyewitness, Robert Fitzgerald. Fitzgerald had a reputation as a jailhouse snitch. A 2005 report by University of Michigan Law School Professor Sam Gross and the NAACP Legal Defense and Educational Fund found problems in the case, as reported by NBC News at the time. The first police officer at the scene of the 1980 shooting, this is how they got this bill to pass so that they could go in and relook over the evidence. Now they acting like there was nothing racist going on, that this needed to be done. You see, when the man questioned whether if anything racist has happened with the prosecution situation, this is what the attorney that came back to defend people in America with, right? So it say at the time, the first police officer, and now if he ain't mean it by that, I guess he ain't gonna have no time to say Your Honor. He can't say nothing about that. He can't hold up his hand and say nothing about that if the man die. But I guess he got many more times to keep doing the same thing, right? Or whoever else take on the next one that they find insufficient evidence, or find out that it was racism going on with the trial, with the next trial. You know, they got other people up there. Suppose our witness was false. See that? Even though Rogers' own testimony at trial, just like this man came and testified and recanted his statement that he made in at that year when they was trying to prosecute Brother Williams. Even though he came back because the government passed this bill where they could go in and try to get people out of this death row situation if they innocent. And if they not innocent, then the death row thing need to stop anyway. right? Because if everybody is not going to be put to death for slaughtering, and I'm saying this is my statement, if everybody ain't going to be put to death for all the slaughter of the thousands of Negroes that been slaughtered across this country, and just in 2017 alone, if the people that slaughtered our people is not going to be given the death penalty every time, why is they giving our people the death penalty with insufficient evidence in all this? And if they was putting our people to death before this government thing that was started, imagine how many more of our people was put to death that was innocent. And we know a lot of them was innocent. We know because we come from the families of the people. Now says the story told by the supposed eyewitness was false, even though Rogers' own testimony at trial supported what the witness said. A second victim of the shooting, Wallace Connors, has said he was never contacted by the defense or the prosecution. So the defense wasn't able to cross-examine this person. You see that? The defense attorneys was not able to cross-examine the witnesses on the stand. So they just went on ahead with a proceeding. It's like you never even had court. The prosecution came in, they said what they had to say, and you might as well put a circus tent up and let everybody go in there and put some ropes up over there and say, okay, you scheduled to be lynched this day, that day, white or black. You're scheduled to be lynched, right? Connors, now 52, was wounded in the attack, said the supposed eyewitness was not present at the shooting. So he wasn't even present at the shooting, but he's supposed to be wounded at the attack. An investigation by Gross and NAACP Legal Defense and Educational Fund found Wallace Connors, the wounded man. He said he saw the gunman and that it was not Larry Griffin. Connors said he had never been interviewed by police. Following the report, a collision included Missouri House Representative William Lacey Clay, high-profile lawyers, and the victim's family called for a reinvestigation and a case to clear Larry Griffin's name. Jennifer Joyce and the St. Louis Circuit Court attorney at the time did reopen the case. And in 2007, release a report. Now, this is before Michael Jackson passed away. I'm saying the names of key people. If I name myself or if I name Brother Moshe or anybody, it's so our mind could try to kind of like go back and have a feel of the time of what we was living in, okay? And in 2007, released a report that, so pay attention, family, that her investigation found a new witness identified only as Carl Doe. Understand, pay attention. Who claimed he was Fitzgerald at the scene of the shooting to buy drugs. Not because Fitzgerald's car broke down. The report also claimed Connors was interviewed by police 3 times within 36 hours of the shooting and said he could not identify the gunman. However, Joyce's credibility in these matters, given her history, is questionable. Larry Griffin is the uncle of Missouri death row in exoneree. So that's in family. That's family. You see that? Death row in exoneree. Reginald Reggie Griffin. Support death row penalty in Missouri by making a donation today. So look, support death. They want you to support the death row penalty, even though they're putting to death a lot of innocent people. This need to be stopped. How you gonna make judgments on people when this system ain't right? This country was not built on freedom and equality. And if you don't want 97 executions done happen, That's not a victory. That's like 97 people failing in school. Do you want 97 failees in school? That's 96 executions, and from the looks of it, a lot of them was innocent people that was put to death. This need to be put to a stop. Will they put it to a halt? Well, this is what this program is all about. This is a shame. So this is what this is all about. Missourians to abolish the death penalty. All right. Now let's go over to here to the brother, the news story that came up on the brother right here. Now this right here is the Missouri Supreme Court considers death row inmate appeal as execution date looms. Attorney for Marcellus Williams argued testimony that black jurors were excluded in Williams' trial means he should be given a reprieve, no matter if they made a mistake or not. Why should you put to death an innocent man if you don't hear what the innocent people got to say? If you don't hear what the defense have to say, how can you prove whether or not if the conviction was based on true merit or based on bias? How if you just let the prosecutor cross-examine the witnesses and the defense never cross-examine the witness, maybe they did that because they thought that they didn't have enough evidence. I don't know. But what I'm telling you is that they still should go off of evidence. A prosecuting attorney is not supposed to prosecute somebody just because they're a prosecuting attorney. And I'm going to show y'all that law if y'all are willing. But in the meantime, I'm going to let y'all listen to them while I get this information for y'all. Let me send y'all the article, well, not the article, but the website that I was reading from so that y'all can have y'all a copy as well. Everybody in the chat, type A if you believe that the defense should have the opportunity to cross-examine before they put to death somebody. Or type B, if they didn't do it, they should still proceed even though they're trying to get it right. They should still proceed and with the death penalty. Type A if you believe that this is the right way that they're going about it. And type B if you believe that it's the wrong way. And I forgot how to share this. There you go. Copy link. All right. So I'm finna send y'all this link right here. So type A if you believe that it's right that they don't cross-examine. Type B if you believe that it's probably you didn't hear me correct. Type A if you believe that it's good how they going about it by putting to death innocent people. Or B if you believe right. So you agree with what the defense attorney is saying. If he's innocent, let him go. Do you believe that they should put him to death if he's found guilty? But they ain't looked through no evidence, and no evidence show that he's guilty anyway. They tampered with evidence, and a witness came back and recanted his statement. So do you think that they should abolish the death penalty and just let people spend out their time in prison? Or do you think that they should have a death penalty to take people out that ain't going to be in general population anyway? Which one do you think will be more merciful to a person? Which one do you think will be more what they say when we was growing up in school? American. All right. So if they execute them, they have blood on their hand, right? Now, I'm finna look up the can a prosecutor charge for fallacy? Okay, here we go. And then you can find it right in here. I'm sorry, I bumped the microphone. The prosecutor fallacy, Center of Evidence-Based Medicine. All right. This is why people go to school to study, so that you can know the laws of what's going on. You can know when there is something that ain't right. No, look, a prosecutor are not charged for logical fallacies. Look at this. But they can commit them, which can lead to miscarriages of justice. This is what they doing right now. This is what the defense attorney is trying to say. It was a miscarriage in justice. A common logical fallacy that prosecutors commit is the prosecutor's fallacy, which involve confusing conditional probabilities. This fallacy can be avoided by making sure the probability answers the right questions, focus on how the evidence applies to the defendant. If the lawyer made an error, how, and they talking about something else. We're not talking about the errors of defense attorneys or anything like that. We're talking about miscarriages in justice in totality. Focus on how the evidence applies to the defendant. If the defendant didn't commit the murder, if the knife, the murder weapon, cannot be traced back to the defendant, why is the defendant being on the death penalty? Not ignoring other factors that may modify the likelihood. Not ignoring the other fact. So why do they got this brother sentenced to death in 2001? Ain't that's modifying the likelihood? The prosecutor fallacies occurs when a prosecutor confuses the probability, and this is what has happened, that an individual matches the description of the guilty person with the probability that an individual who matches the description of is actually guilty. So the murder weapon does not trace back to Brother Marcellus. This is what the prosecutor was arguing, that this is not what's going on. But if the murder weapons does not go back to Brother Marcellus, because they was doing DNA and forensics and stuff back then. So if the murder weapon does not match Brother Marcellus, then this is what's going on, right? And this is what the judge is supposed to spot out too. But who is prosecuting him? Where's the defense? Well, I'm saying, like, how is this a defense? They made a ruling in 1998, 2021. They did not, the defense was not cross-examined. So this is a miscarriage of justice. And if the defense was not able to do it, then it's still a miscarriage of justice. If they was able to do it, it's still a miscarriage of justice. The prosecutor might argue that the odds of the defendant being guilty are very high. However, the prosecutor has ignored the size of population in question. The prosecutor's fallacy, Center for Evidence-Based Medicine, University of Oxford. So if they saying that this is wrong, then they need to discontinue Oxford University. If this right here is illogical of what they arguing, then Oxford need to be shut down for teaching people, for teaching lawyers stuff that they ain't supposed to teach. Now let's go back and listen to this, and I'm pretty sure that somebody can argue this better than me, but I think I'm making a good point here. I think I'm making a point. So here you go again, and we're gonna listen to him finish his statement, but I had to go over that again, fam.
They should have done better than that, but it's not the court's fault, it's not my fault. And they also criticized this court for setting an execution date under 3030 when the case was pending. Well, this court followed the law. 3030 says when you set an execution date what the requirements are. And
So if y'all doing that, right? If y'all doing that, if he is a Negro, why don't y'all put him? See, if y'all gonna go against the law that y'all set up now, that's against what y'all was doing back then. Like, I mean, back then it was lynching, NIGGERs. Back then it's a lot of stuff. I mean, it's still going on today, ain't it, sir? So, I mean, come on now, work with us. If you saying that y'all trying to get justice, how come the defense is not? The defense is telling you right now what happened. They telling you right now what's going on. We're not in 1800s. We telling you right now whether, and we know the 1800s look like it look right now. It's just more suited up and more dignified looking, but look at what's going on now. And I know I can't really say nothing to him until they get this fulfilled, but I'm just talking in formalities. This don't make no sense. Okay, let's listen to more of his argument on the reason why he gonna hold fast to, and we're gonna call it what it is, a white supremacist law to put to death people without cross-examining without the defense being able to cross-examine, by the prosecutor only being the one that's cross-examining it.
you didn't do anything wrong by following the law. The judge didn't do anything wrong by handling the case the way he did.
Really? So he's saying that he liked it the way it was back then. He's saying he don't like what they doing, what they pressing for right now, where they trying to stop the death penalty, and if a person, if they guilty, just let them stay in prison for life or whatever. He don't like that. He wanted to be how it was back in the good old. I mean, that's what it sound like. I mean, this what it sound like to me. He's saying he don't like. I mean, because if he's saying that he's standing up for what they did in 1998, then is he agreeing with what they was doing that was unjust in 1998? Like, what about the crack crime bill? What about those? Do you agree with that? You see what I'm saying? You agree with them giving people life in prison for having grams of crack? You agree with that? Do you agree with redlining? You agree with that too, sir? So if I was a crooked person, could I go to you for you to defend me? If I was redlining people, I could go to you. If I did something, and I could just go to you, and because I got the complexion for because that's what they was doing. I mean, think about it. And with redlining and stuff, this is where this came from. Jim Crow, 1970 something. This, when they reinstituted this back in 1970 something, it just came out of the 1960s, and the 1970s, they just came out of 1960s. So in 1970, you can't just, think about that. You can't build a house in one day. So it take time, and you know this. It take time for if something was bad for 500 years, for it to just go away in 1 year. So in 1970 something, they instituted the death penalty back in. And okay, so they instituted it back in. So is you saying, sir, that you want to go backwards? You want to go backwards while your comrade, while your brother is trying to tell you to go forward? Your brother sitting in court with you, he telling you to go forward with doing things the right way, and you want to go backwards, sir? So listen to his argument.
The prosecutor didn't do anything wrong by touching the knife when there was no reason to believe that there was a reason not to touch the knife. And the prosecutor did not make any strikes that were partially based on race.
So if they was checking to see prints and stuff back then, right? And if there's no reason to even check the knife, right? Then what was the other probable cause, or what is your reasoning in that? You see what I'm saying? They say justice is blind. Yeah, they say justice is blind when it comes to our people. Justice sees no color, right? Yeah, justice sees color. So do this make sense? You know, how can you justify the man touching? So is that the new standard in court? We got to touch weapons. You can touch the weapon now because somebody made a mistake and touched the weapon because they didn't feel like it was necessary to even touch it. He automatically looked guilty. Well, I mean, what is it? What is your argument? What is the logical, common sense argument that you're trying to make? What is something that makes this? If you was Mr. Williams, would you be making that argument against yourself? If Mr. Williams was your client and you was trying to protect him, would you make that statement? Would you make that statement for any other geographical person? Does this make logical sense? If you was in that case, would you want somebody to say, it don't matter who touch on the weapon or not, and y'all just came out of Jim Crow? You just came out of the plantation? Just came out of redlining? Just came out of sharecropping? Don't you think that is a probable cause that something was going on back then, sir? Do you think that it was justice and peace for everybody back then in 1970? Are we not still having the same racial issues, sir? Because the name black and white comes from slavery. That didn't come before America was established, sir. There was nobody so-called called black and white. Everybody was named after their nation. That doctrine came from Blumenbach, and it didn't just come from Blumenbach, but it also came from the ancient Greek Empire. That because of the features of a person, that they ought to be the slaves, the white man's burden. Blumenbach put people in classes of color. The darker skin complexion people, black. Other people, yellow. Other people, brown. And there was a classification of who could be classified as white. White, at the establishment of this social class, was established to put white men as the beneficiaries of liberty, but to put the darker skin complexion people as the lower class in society. We were not allotted to have any rights. And are you arguing that it could go back to slavery? What is your argument, sir? Speak clearly to us so that we can understand your argument, because you're not arguing something that makes sense.
The argument that they made in their motion to vacate is exactly the argument this court rejected in the direct appeal opinion, which was it's race-based because they look similar. And this court discussed that and said, no, it is not race-based. And now what they've got is he used the word brother instead of they just look similar. He said they look like brothers, and they say, that is an admission that the strike is race-based. No, it's not. It's the same thing he said to the...
Brother Moshe, if somebody looked at me and you and they say, if any one of y'all, Moshe, Moshe the commentator, Moshe, Monster Moshe, Sister Melanated Queen, if somebody looked at you and they say, hey, y'all look the same. Y'all look like brothers. Y'all look like y'all is the same people. Y'all, yeah, they look like brothers. So he's saying, look, they look like they kinfolk. They look like brothers. And in America, when you classify somebody as black because their skin is dark, and you bring other folk in here and they come in with they tribal names and stuff, and we is left with classifying as black. You put them in the mix, and then you say black people, and then we have no identity, so we just blend in like the lost ant walking on the ant pile. He could say, make an argument and say that that's not true, but how can you tell me that that's not true? It don't make sense for you to make an argument and say that's not true. That's like you saying that a fish don't need water to breathe. Because if I can make the same argument about you and say, well, if the other hand was flipped and we say, okay, we was a slave master and we took away y'all identity, y'all language and everything, and then we classified y'all as black, and then we bring in other people who have tribe names, and then we say they black people, and then somebody look at them and say, hey, is that a brother? If they don't say nothing, I will even say it myself. Yeah, that's a brother. If the Ethiopian Jew came over here inside of the broadcast and I put him up in the panel and he looked at me and you looked at us and you said, do he look like a brother to you? And I say, yeah, he looked like a brother to me. I got cousins that look like Brother Marcellus. So making that argument, that's a straw man argument, sir. That could go anywhere. That's why when you make a straw man argument, that's what the lawyer was telling you. That's what the lawyer was telling you. No prosecutor are not charged for logical fallacies, but they can commit them. So if the lawyer made a logical thing that you called a fallacy, how can that be illogical? Which can lead to a miscarriage. But even if it was an illogical fallacy, why does it lead to a miscarriage of justice, sir? Why do you think this is the reason why this case need to keep on going until this man life is gone out of his body? So this is what people are saying. This is what they saying. So I'm finna let him finish his argument, and then I'm finna let the defense argue.
This court reviewed 20 years ago, just with different words. And when they actually asked him the question, it was no, absolutely not. I did not strike him because he was, in part, because he was African American. That's what the record says. And what the district court said, which they don't like, but the district court who reviewed this last week said, not only is that a mischaracterization, you can't even draw an inference from this record that it was race-based. And it isn't drawing an inference, it's proving it by clear and convincing evidence.
Okay, so I had to stop that. So who set up the pot? Who is the one that brought us over here? Who is the one that set it up where it could be unjust? What neighborhoods did we grow up in? How was the police set up? I'm not talking about how they are now. I said, what is the origin of police? So when you say a black person did something, how many questions is asked? How many questions is asked? What is the probability of a black person, what you call black, because that's come from racism, or a white person that you call white because that come from racism, that the website calls white and black because that comes from racism? Right here, Anderson Terrace, black, that comes from racism, sir. Nobody was called this even in the Bible days. Nobody was called this before the Germans came to colonize the middle of the East. Not the Germans, before the Greeks came to colonize the Middle East. Why was their name changed? What's going on? Why don't Negroes speak their native tongue? So we know that we just came out of a horrific situation and we still in one, if we'll be honest with ourselves. Are you making an argument to state that there was no racism going on in the 1970s?
They didn't prove it by any evidence, certainly not clear and convincing. Probably I should ask the questions again. I don't want you to go away not having me answer anything you want to know. All right, I would just say this. Nothing they have is preserved. I don't think this court has jurisdiction to hear the case, but I would ask that you write an opinion that addresses the merits of these issues ex gratia, or however you want to do it, so that you can do it in addressing the state. Because I...
Hold on. Okay. If I say a lion got loose out of the zoo in Africa, what are they going to go looking for? Lions, right? But if I say, tell me if everybody know who I'm talking about. If I say Negusi, and I'm saying in the Gaaz, in the Geese language, if I say it's Negusi running around out there, a Kushi, it's a Kushi man and a Kushi woman. The origin of black comes from the Latin word nigger. Well, that's not the origin of it. But in Latin, when the Europeans was using it during biblical days, it was called nigger. And it's pronounced with a hard E and a hard two E's. Nigger. Black. It is the same word that was counter. It can mean more. The Moors. From Spain and Portugal, these are the people that you have in your possession as oxen. How can you tell a nation that thinks a certain way that your ways is insufficient? So since you didn't simulate your opinion about what I think about you is not factual. Even though I'm not you, I'll make a logical argument according to my bring up or what I think you should be in order to establish that you are black and white people. When in fact, black and white came into existence because of race. Racism. That's what race means. Racism. Black and white classes. Black and white racist. The black racist. The white racist. So in order for you to identify with them as Adam, human beings, you have to go back to the origin of what people are. So when you make a classification calling people black and white, that was a racist practice, sir. So when you say it was a black male, what is the automatic thing to do if the law's original root was established to prosecute black people? The 13th Amendment abolished slavery. White people was not in slavery. Only it abolished slavery only if the person is convicted of a crime will they be eligible to be a slave again. The practice can go on. So the classification of calling someone black with the very law that was written for the people that's calling themselves black out of ignorance, or being called black out of that same ignorance, it is classifying people with black instead of their national origin, which in many cases is criminalized or penalized in every country. Who first made the first ruling for this procedure to go forth? King John II of Portugal. that those people that was first called, look on your African map, sir, on your ancient old African map. I'm not going to tell you the one that we could clearly see, but look up Lam Lam on the West African map, sir. Look up Ouida on the African map, sir. So they're classifying us as black and classified you as white as an inheritance to oppress and enslave us. Because without the black, there is no white. Without the black, you are who your father is, and you build up your nation. We're not together as, let's say, if France and America had a peace treaty and a pardon, we're not together like that. We're under them as if we're crooks. Read Deuteronomy 28, sir. Read the book of Daniel. That's when they first started colonizing the Moors. The Moorshite. Malachi. That's when they first criminalizing the Moorshite, ruling over them in their own home country. And what was then all known as Ethiopia to your forefathers. So classifying somebody as black and white is racism, because those are classifying people as racists. All you got to do is put the T on the end, what our ancestors did, to show a differentiation between a person that is the head, or the person that's the one that is causing affliction, and the other one that's not. So a racist is a person that upholds the system of racism. A race is your geological, whatever you called it, what color you look like. So when they said, do they look like brothers? What they were saying is they black? Because everybody at that time saw us as blacks, and still do a lot of times. What application do you have, sir, with Soyuta? Because that's where we was taken from Africa. What application do you see on there has Lam Lam? Well, we can type in and put a name in there. When the police officer go to look out for a black male, do they put Lam Lam American? Or do they say a black male, or a black female, or a white male, or a white female when the police go looking for a suspect? Do they say a Japhetite from the tribe of this one? Or do they say a white man on block so-and-so, let's go and pick him up? So you see, that was racism going on. That's why we're classified as black and white. Brother Moshe say, my beloved brother, they biggest salute, Ak Moshe Bin. Aman.
I think that's important. And if you could find your way to say that the prosecutor isn't Satan, I'd appreciate that too. Thank you.
Thank you, counsel.
Counselor, do you agree that neither you nor Mr. Williams used the time that the court allotted for you for the hearing?
No, there's no dispute that the full amount of time wasn't used, but that's also because you have to make strategic decisions based on the amount of time that you're allotted and whether you can call the witnesses who you want to call. For example, Mr. Williams was going to be testifying likely for an hour to an hour and a half on there. There was no opportunity to actually put him on the stand because of the...
Okay, I'm going to address that what you said about Satan. Satan means, in Hebrew, Satan means the accuser of the brethren. Go look up the evidence. Satan means, Hashatan means the accuser of the brethren. Black people see themselves as brothers and sisters. A brother is being accused. If I was accusing Brother Marcellus, I would be an accuser of the brother. I would be a Satan. If the brother is innocent, I'm accusing him. If I believe he's innocent and a person is trying to say that he's not innocent, then I'm going to look at you just same way on your side. If you said, hey, my brother is innocent, and I say, no, he's guilty, I am the accuser of your brethren. If he's innocent, then I'm saying that miscarriage of justice should happen to your people. If I condemn those who are guiltless, who don't have a guilty conscience because they didn't do it. Okay.
The limited amount of time that was there. One of the
So between you and Mr. Williams, there was 4 hours allotted, and then the state was allowed 2 hours, is that correct?
To be clear, there was 2 hours for the prosecuting attorney's office, 2 hours for Mr. Williams, 2 hours for the AG's office, Your Honor.
And then what about the fact that you filed no 7807C motion? I mean, there's, this court has case law, regarding the juvenile cases where there's a requirement by statute, not necessarily even, requesting findings of fact, even in cases where the statute requires you to make findings of fact. If you think one was presented that wasn't found, you're required to bring that to the trial court's attention.
I'm glad you asked that because I have a couple different responses to that. The first one is the issue here is that the court didn't reach the merits. This isn't about the form and language. It would be about the form and the language if the court had actually reached the merits of the Batson challenge.
But didn't they read, I mean, the court made a finding that the prosecutor denied striking jurors because of their race.
So Judge Powell, that is not what the finding is, if I can gently push back on that. That is at most a summary of testimony. And all that summary of testimony says is that he denied systematically striking black jurors. All that Batson requires is the striking of one black juror. That is clear under Flowers and all the U.S. Supreme Court's precedent. So it's non-responsive to the issue at hand, which is whether juror number 64, who said that he was willing to impose the death penalty, provided no pushback to that to the prosecutor whatsoever, and should have been an ideal juror, except for the fact that according to the trial prosecutor, he was a young black man with glasses. That is unacceptable under the Constitution. With respect to the jurisdictional issue, I also wanted to say the court should be, I think the court clearly has jurisdiction. It would create enormous problems. Think about ballot measures, just thinking about last week. If we're going to deprive this court of jurisdiction just because something's on an expedited basis. The court has jurisdiction over a judgment. The finality rules, that refers to the triggers that will relate to everything else. And with respect to the inability to, address the form and language, Your Honor, we can't be put in a catch-22. There's no way that we are going to have the time to actually come and brief this before this court. We're already here on Monday morning before the day of execution. There's no practical way. With that, what we would respectfully request is that the court would either enter judgment with respect to the trial prosecutor's motion, or alternatively, send this back to Judge Hilton so that he can make the actual findings that are necessary for this Batson claim so that this court can review it. We thank the court for its time.
Thank you, counsel. Matter be taken under submission. The court will be in recess.
All right.
All right. So the court in recess. The court went into recess and they was gonna come back, and I left the link down there for y'all. Y'all could go and follow that channel so y'all can know what's going on out here. Family, it's getting about that time. I'm finna pray Not a long prayer, but I'm finna pray. And if y'all were willing, drop the link for y'all to come again if y'all would like to come. And again, you can share it if you come live here. There's an ability for you to, while you're live, to share this to your live screen, and you could be going live on your page at the same time. Most holy and everlasting Father, you see what's going on, Father. Father, we need your help. Only you are able to fix it, Father. Father, remember all of the things that you have done. We know you're able. Father, are you willing? Father, we read of what your word said. Please lead them to make the right decision, Father. Please lead them to make a decision that won't cause someone to lose their life that should not have lost their life. Please hear us, Father. We give it to you. We give it to you. Father, I lift up Brother Marcellus Williams. Father God, I lift up all of those whose life is weighing in the balance. If all 10 of these people are innocent, whether if they're classified as white or classified as black, if the evidence show that they are innocent, Father God, please let them go. You said, I come to set the captives free. I come to set at liberty Father, y'all, please help. We don't know what else to do but call on you. There's too many people dying, Father, y'all. Family, look at the brother in his face. Look at his face. Pray for the brother. Yahweh made him. He made him to live. Finna let this number show before I get off of here. He ain't got long, fam. Father, y'all, pray in your only begotten Son, Yahushua. Amen. Now may Yahweh keep you, and may he bless you. May he make his face to shine upon you and give you his peace. Shalom. Amen. Shalom, sister. I was about to leave. If you want to come up, you can. I'll wait a little bit longer for y'all to make your mind up. All right, Mashpakah. If that's all, I want to leave y'all with a shalom. Keep your brother and your sisters and the innocent in prayer. Shalom to you.